Magandang araw po mga kawangis ko. Kung saan man sulok ka man ng mundo, ito ay inyong lingkod, Anton Olson, sa mga kapwa ko OFW. OFW dyan sa Middle East. Yung insight. Sa mga nakasubscribe na sa akin. Syukran ka. Ngayon malungkot po na balita kasi nga alam niyo mga kawangis ko, parang hindi pinagbigyan ng ICC yung interim release ni Pangulong Duterte. Pero kahit papaano, umaasa pa rin tayo for the next future, sa susunod na mga araw na mapagbigyan si Pangulong Duterte kasi sa edad niya na talaga na 80 anyos na siya, hindi na siya makapaglaban ng ganyang sistema. Kung sa madaling salita, baka nga si Pangulong Duterte may pagkaulyanin na yan kasi ang ibang mga 80 years old parang doon na pumupunta eh. Pero mapapansin mo pa rin sa puso ng mga Duterte family, parang doon pa rin yung kabaitan nila, yung doon pa rin yung pagtanggap nila. Ito po nagpadala po ng Duterte family ng kanilang mensahe. Ito basahin po natin. The family accepts the ICC Appeals Chamber's decision with peaceful hearts. We will continue to work with the defense team on the case and will keep supporting former President Rodrigo Duterte with our daily conversations. We thank everyone who prayed with us today. Di ba? Nandun pa rin mo makikita ang kanilang conviction, yung mga pamilya Duterte. Kaya doon mo mapapansin na ang dami pala nagmamahal sa Duterte family at ang daming mga supporters kasi ganito pala kahaba talaga ang kanilang pasensya, understanding sa tao. Tingnan mo kung sa ibang ano 'to, sa ibang mga nilalang na 'to, sa ibang tao. Nandun yung magulang mo sa ibang bansa, gastos, emotion ang inaano mo dito, gastos, emotion, kung ano pa. Ang layo, 'di ba? I hope someday, I hope someday in the future sana makalabas na siya, 'di ba? Yun lang kasi ang pinaka-ano, yun lang kasi ang pinaka-importante na makalabas si Pangulong Duterte. Ah, ito po panoorin natin po yung ano, yung statement dito ng sa ICC kung bakit hindi natanggap, bakit hindi pinagbigyan ng interim release si Pangulong Duterte. Ito, pero ang haba. Ano lang 'to, parang summary lang.
B of the statute, a chamber assesses whether the arrest of a person appears necessary. 1. To prevent a person from not appearing at trial. 2. To prevent a person from
Lang ako.
obstructing or endangering the investigation.
Parang nagbabasa ka mukha ni Madam Auring, no? Naalala lang, hindi ko hindi ko kasi mapigilan. Ang puti ng mukha. Which is maputi naman talaga sila. Pero similar masyado kay Madam Auring. Alam mo, nagbabasa ng bulang kristal. O sige, proceed natin.
Or the court proceedings. Or 3, where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. In accordance with Article 60.2 of the statute, the person subjected to a warrant of arrest under Article 58 of the statute may apply for interim release pending trial. The Pretorial Chamber's ruling on such an application under Article 60.2 of the statute is provisional in nature, to the extent that it will be periodically reviewed at least every 120 days or at any time following a request by the detained person or the prosecutor, if satisfied that the circumstance so require. The Pretorial Chamber may modify its initial ruling on detention, pursuant Article 60.3 of the statute and Rule 118.2 of the Rules of Procedure and Evidence. Regarding the first round of appeal, and the question of whether the pretrial chamber erred in law by relying on hypothetical goals, that in determining whether the conditions pursuant Article 60.2 of the statute had been met, a chamber must find that detention appears necessary. In this context, the appeals chamber observes that a determination shall be made concerning the possibility and not the inevitability that one of the events listed in Article 58(1)(b) of the statute will occur, and that it is the responsibility of the relevant chamber to weigh the evidence before it pursuant to the relevant standard. The appeals chamber notes that in its assessment of
Umiinom din
risks
pala ng tubig
under
si Madam
Article
Auring.
58(1)(b) of the statute, the Pretorial Chamber
Daan na lang natin
relied
sa mga
on
tawa-tawas,
this
mga
legal
jokes-jokes,
standard.
kahit
Indeed,
malungkot.
the Pretorial Chamber correctly referred to the standard that the assessment under Article 58(1)(b) of the statute concerns the possibility, not the inevitability, of a future occurrence. It then analyzed the material before it against this standard. Accordingly, the defense has failed to demonstrate that the Pretorial Chamber misapprehended the legal standard relevant to the assessment of risks under Article 58(1)(b) of the statute. With regard to the Pretorial Chamber's assessment and weighing of evidence in assessing risks pursuant Article 58(1)(b), subparagraph 2 of the statute, the Appeals Chamber notes that the Pretorial Chamber made reference to 5 documents, including media articles, publications of non-governmental organizations, and a book which, in its view, indicated that Mr. Duterte's inclination to interfere with investigation against him. In relation to the first document, a media article, the Appeals Chamber finds that it was not unreasonable for the Pretorial Chamber to rely on this document for its finding. Whilst this document does not mention Mr. Duterte himself as being directly involved in briefing individuals, it does not refer to statements of close. It does refer to statements of close associates, including one where individuals would have been told to remain loyal. In any event, the Appeals Chamber observes that Mr. Duterte's alleged involvement in briefing individuals is but one of the factors that the Pretorial Chamber took into account to support its conclusions on Mr. Duterte's inclination to interfere with investigations against him. In relation to the other 4 documents, a book, 2 publications of non-governmental organizations, and a press article, the Appeals Chamber recalls that there does not exist in the applicable law of the court any impediment to use of newspapers, articles, or other public or open sources for the purposes of assessing the requirement under Article 58(1) of the statute. Nor is there any requirement that such material be corroborated. Noting this, the Appeals Chamber considers that it is possible to discern how the Pretorial Chamber reached its conclusion on Mr. Duterte's alleged involvement in the threatening and taking of retaliatory actions against individuals opposed to him. In any event, the Appeals Chamber observes that this is only one of the factors that the Pretorial Chamber took into account to support its conclusion.